Seems a few people are opinionated on a lot of subjects, so I'll make it easier for a few of them. One in particular is I'll refer to this gentleman because he has some idea that he went on one of the posts and said he's read the state constitution and he can't see the difference between this one and this one. This one is the one with 32 sections missing, and it 1889 to 1980. It has 32 sections missing. Therefore, it is invalid, unlawful, whichever way you like it. This one was put in place with a letters patent. Why? It says so. It says so. And on the 29th of October 1900, Queen Victoria made sure it was in with a letters patent. So, Anne Toomey, I've heard your reference to this, and I'll tell you now, it's not true. It's nonsense. But I'm not going to refer to you much yet, because there's a couple other people, smart people. They know everything. And I've just about had enough of people getting smart. And another one, Darryl O'Brien. I'm going to take my blinkers off, because there is two versions of the Constitution. Well, whoopee-doo. I've been saying that all along. Haven't you been paying attention? Perhaps, Darryl, you pull your head out of your butt. And I'm sick. No, I'm not sick at all. I had a guts full of people like you. This is the green one, which is fraud. This is not authorised by the people. It was authorised by political parties with absolutely no lawful authority to do anything. And this, according to Anne Toomey, is exactly the same as this, which is a lie. Did Anne Toomey set the lie up? I don't know. Am I interested? No. I'm interested in the fact that she's sprouting about it. And I'm even more interested when you, Darryl, think you know everything and you try to mock me. Well, I'll mock you back. You're not telling the truth. And I can prove it. I've got the documents to prove it. And then there's another guy, Mr. O'Brien. I'm not going to insult you, because I've given you the chance to contact me and you want to discuss it. I can send you the documents which prove what you said. McLeod, sorry. Yeah, McLeod. I got that name wrong. Yep, but anyway, it doesn't matter. It's rectified now, Mr. McLeod. You said that the Constitution is ultra-vires, and you gave several reasons. Well, I don't know where you got that information from, and it isn't. This is just turned off. Why? You just did it all on its own. Never touched nothing. Alright, we had a little bit of a hiccup then. Mr. McLeod, I was referring to you. This is not ultra-vires. If you took the time to read this, you would find out that interpretation of this is in the Maroon book. That was written by the people who framed it. It was documented by Dr. John Quick and Sir Robert Garran as truth, as a public record of facts of law. This is not ultra-vires because of the reasons you said. There was no referendums before Federation. They were self-governing colonies of England. Each colony, there were 6 of them, and they couldn't hold a referendum. And there was no legislation for a referendum. There was a vote taken in relation to the draft copy at the end of all the conventions. I get that. Western Australia did not have a referendum to go in 1890. That's another description of what you said took place, and it didn't. How do I know? I got the documents that prove it. I prove it. And you've got to listen or ring me and I'll send you the documents which prove it. But nonetheless, the document, you referred to section 74. Well, actually, Queen Victoria had a hand in putting it in, not taking it out and not questioning it. The whole idea was access to the Privy Council through the High Court. And you say there was a dispute and there was all this garbage and needed to go back to the people. No, it did not. The people, so you know exactly what took place, the people or the representatives put the Constitution together as a draft copy. Why? Because they were all colonies of England, answerable to England under their state constitutions. Whether you like it or not, that's how it is. And that's what you have to understand. Because that's what they were. You couldn't have a referendum without lawful states. And they did not exist until January the 1st, 1901. They were put in place under the provisions of 107, 108 and 109. Now getting back to the Constitutional Act itself, which is here, as proclaimed and gazetted, this is an enabling act. Western Australia didn't put in an enabling act at all. I don't know where you got that nonsense from. If it's from AI, punch your computer and throw it in the bin, because AI is full of garbage and lies and fraud. Now, you understand what I'm saying, because you better be clear, because I'm sick. Well, I don't like that expression. I've had enough of the nonsense. I'm trying to teach people who want to listen, not people who want to promote themselves. There's no public record that says what you said, except what may be now or might be in the green one. But the green one is, as I said, nonsense. We had no input into that whatsoever. Now, when that draft copy went to England, Queen Victoria added 9 clauses. And Toomey will tell you there's only 1 clause left. Rubbish. That's a lie. Whether she's lying, I don't know. She puts herself up as a professor. I dare say she would have the knowledge to say whether it's truth or not. She should at least check. But she said both the green one and the red one are the same. No, they're not. I've read both. I've got both. Show me where they're the same. They're not. We've got 260 pages of foreword in the red one. And at the end of it, on page 262, starts the Constitution, starts with the 9 clauses. Then it goes 1 to 128. And then after 1 to 128, you sit down and there's the oath. And then it goes back to number 1 and explains completely the interpretation by the people who put it together. Why would you want anyone else's interpretation, which is what they put in the Green Book? Interpretation by, professors. Look how many times you've got it wrong, Ann Toomey. Look how many times you've got it wrong. You go in there and sprout all your nonsense. Oh, look at that. We don't need a referendum for the Australia Act. Is that right? That's interesting. This is the Australia Act. Nice Australia Act. And this is what it says. An act to bring constitutional arrangements affecting the Commonwealth and the States into conformity with the status of the Commonwealth of Australia as a sovereign, independent and federal nation based on what lies? What lies are you talking about, Ann Toomey? I just watched your video last night. I couldn't believe you said all that garbage. But it doesn't get any better for you. And whereas in pursuant of paragraph 5138 of the Constitution, the parliaments of all the states have requested the Parliament of the Commonwealth to enact an act in terms of this act. Have they? Well, your big problem is the same problem as local government and all the rest of them. But before we get into that little bit, there's something else you should know. We don't have a lawful Governor-General and haven't had since 1960. This says so. What's this? You gave a big spiel on what you think is the Queen of Australia and what it means. Elizabeth II by the grace of God, Queen of Australia and the other realms and territories, head of the Commonwealth. And you said, oh, well, there's no grace of God and there's no Queen of, by the grace of God, Queen of Australia and the other realms. No. She's not. She's a Queen of Australia as a realm. We are her subjects by way of the Constitution. The issue then becomes, that's an alteration to the Constitution. It refers to the Queen being the King or Queen of England, as the time may be. But I'm not going to argue that, because all the sections of the Constitution say what you actually said in your video is nonsense. Why don't you correct your faults? And in relation to the Australia Act, the first part of the Australia Act didn't appear in England, number 1. And it says, an act to bring constitutional arrangements affecting the Commonwealth and the States into conformity with the status of the Commonwealth of Australia as a sovereign, independent and federal nation. No. Why wasn't that put on the act presented to the Parliament of England? And why didn't they come back to Australia and get the permission of the people, which they didn't have when they went there? And now you're telling everybody they didn't need it. And it was passed and signed off by the Queen. All lies. All lies. Nothing more. Are you a liar? I don't know. You tell us. You're the one putting forward the story. You have the onus of proof to prove the statements you make. Are you going to prove them? I don't think so. You just go back. You won't discuss it with anybody. You know everything about everything according to you. And you're an expert. Well, in colloquial language, an expert is easily defined. It's very, very easily defined. An expert, an exercise has been, the spurts of drip under pressure. Do you fit that? Do you fit that? If you don't, then explain what you mean when you put all these things out. Or you answer people's questions. You don't actually answer them. It won't go off now, this stupid thing on the thing. I'll leave it to you to know. We're having a little bit of problem with the internet, which we usually do. Even if you didn't like it, when you look at section 5138, which it refers to, with the conferral of all the parliaments of the states, the Commonwealth can exercise authority it had at Federation. Well, Quick and Garran, the framers of the Constitution, and all the framers said there wasn't any. They had no authority, because the Parliament wasn't even established then. And the reason I'm going to go back to that is because it never was established, ever. And you can't say it is without evidence to the contrary. Don't come out with your fact checkers and say I'm wrong, because I'm not. I have the documents which prove exactly what I'm saying. Exactly what I'm saying. Now, you have a problem, because there wasn't any, and Quick and Garran said, but even if that wasn't so, there was only 7 legislative areas ever exercisable by the Australasian Council, and even less by the colonies, and all 7 are contained in section 51 of the Constitution. And there is no authority ever granted to any parliament of any state or the Commonwealth over land. And then it includes the land, which is the Commonwealth. No power over the land. Authority to pass laws for the good governance and well-being of the people, not over the people. Do you comprehend that little bit? Oh no, too far out of your reach. But you're a professor, aren't you? What are you professing? Other people's lies or your own concoction? I'm not insulting you. I'm asking you for an answer, because you go on there as an expert and spout all this stuff, what you think. I don't care what you think. You need a referendum to even scratch yourself against the Constitution. 1 letter. That came up in the federal parliament, was upheld by the parliament. And what did you say in there? Oh, Sue versus Hill. Well, explain to me. Sue versus Hill removed the requirements or the conditions set out in 44I of the Constitution. Set it out. It took away so much stuff and declared England to be an independent nation from Australia, or a different nation. Another lie. But the big problem with this is You can sit there and you can sprout out your garbage all the time, but I'll tell you now, you never did any research into that, because how does the High Court, one problem the High Court had at that time was simply, if it made that decision, then how did it have the authority to disband itself? Because if England is a separate nation, then the Constitution doesn't stand, and they have no power to exist without the Constitution. But they had no power to exist anyway, and you would have known that, being a professor. You would have learnt that the other problem arises with the High Court Act. Where's the separation of powers between the Parliament and the judicature at a federal level? When the Parliament gave itself authority to control the High Court with the High Court Act. And where did they get the authority to make rules to control the High Court, giving registrars the right to throw our cases out? And why did the High Court, under their rules, have the ability to go to the Constitution and says, we need leave to appeal. We do not need special leave to appeal. Why is that word in there? The word is in there to try and make out the High Court has these special powers, and so do the registrars, to change what we say. And you don't. You don't. You have to comply with our Constitution. We need leave to appeal. That leave should be granted, because if a registrar takes it out, they perverted the course of justice. R versus Rogerson said so. Do you believe that? Probably not, but I don't really care, because the Constitution says if they refuse to put documents in, they're perverting the course of justice, because a registrar under Harris versus Caledine cannot sit in a judicial function. So where does their authority come from? Where does it come from? Or you aren't going to admit that that is anything. Then I looked at a video with you and Mostyn sitting there where she boosted you up, and you made all these statements about different incidents were going on, and Mostyn held up a little white Constitution which is nothing but garbage, and it's been altered and changed. Where did the authority come from? It doesn't exist. 29th of October 1900, the Commonwealth Constitution Act 1900 UK was put in place with a letters patent. It was already law as of the 9th of July 1900. And under Clause 7, the Australasian Council and the colonies ceased to exist. So did all their laws. The only way they could be reinstated is if they appeared in Section 51 of the Constitution. And you're trying to say, oh no, if you look at this, you look at that. I can look at the stars and dream about a cow jumping over the moon too, but it doesn't justify the nonsense that you've pulled over the Australian people. Why are you doing it? If you're doing it accidentally, then you've got a problem, haven't you? But I haven't finished with you yet. Where did Bob Hawke get the authority to issue a letters patent for the Office of Governor General? Where did he get it? The Australia Act wasn't out. You can't say they had statutory authority. No, they didn't. How do I know all the things I'm saying? It's very, very simple, and I'll come to that in a minute, because you think everybody in this country is under you. You know this, you know that. You know, your constitutional clarion, the whole site should be removed, because, and everyone who are fact checkers for Facebook or any other group should go on there. I'll go on there and I'll show you everything that you said is nonsense. And where it is in the Constitution, it's nonsense. Why? Because I've taken the time to learn our Constitution, and it is not what you're talking. It is not the truth. Now, let's wind back to 1933. Western Australia had a vote. It wasn't a referendum. They had a vote to secede from the rest of Australia because of the abuse of authority coming out of the eastern states, where they decided they weren't going to give Western Australia very much of anything. And that was decided. And then after that, because they weren't going to take it anywhere, the Labor Party was voted in. And what did they do? They picked up that decision and they went to England and try and get it put in place so that Western Australia was taken out of Federation. They did it. The Labor Party did it. The same peanuts that are trying to run this country at present and can't. They did it. What did England say? You can not secede, nor can anybody, because the Constitution is indissoluble and it's binding on everybody, and you can't do it. Now, what does that mean to what you're saying? Can you remove yourself, created as a sovereign independent nation? No. You say you don't need a referendum. That's a lie. You say you didn't need a referendum for the Treaty of Versailles. That's another lie. Outright lie. Not truth, lies. Whoever told you, you better go back to them and sort it out, because it's a lie. How do I know that? Because you took part in a discussion with Chief Justice French, which I read, was about 67 to 69 pages, of the reasons why you can't sign anything outside this country and bring it in here and put it into law. I read the lot, and you were involved in it, Anne Toomey. Don't say you didn't know, you did. So what you did is lie in relation to that. But what did Chief Justice French do? Backed up exactly what Michael Kirby said. You cannot instigate any single thing from outside of this country, any agreement, any treaty, anything, without the permission of the people. And you've never done it, so it does not exist. So you're all sitting as a bunch of liars. Now, let's get back to the federal parliament and its ability to make anything, let alone laws. They don't exist. They have never ever lawfully existed. Why? Because I've already shown you the Western Australian Constitution was put in place with 32 sections missing. Not in its original form as a letters patent as required by Queen Victoria and everybody since. You don't even take any of that into consideration. We only had 5 states at Federation instead of 6. Who joined together? The states. Created under the Constitution, 107, 108 and 109. Where do they get their authority from? HCA 48 in 1996, the High Court ruled they draw their authority referentially from the Commonwealth Constitution. Referentially. What does that mean to you, Anne Toomey? In reference to. 106 allows the state constitution to continue subject to this constitution and altered in accordance with the constitution. So where was the authority for the states to give you permission to recognise the Commonwealth as an independent sovereign nation? Didn't have it. Couldn't have it. Because by 1975 there were no lawful states. Where do states derive their authority for a parliament from? The state constitutions. Am I right? Yes. Both the state and federal constitution says so. But if you go to HCA 39 of 1915, Sir Samuel Griffiths at paragraph 148 says, here you find 106 binds the state constitution and all laws made pursuant to it to the overriding authority of the Commonwealth Constitution. Is that clear? Is that clear? And when the Labor Party went to England and they said, oh, the Constitution Act is indissoluble. The Constitution is indissoluble. Is there a Constitution and Act? Yes. That Constitution became the Act here. Did it need a referendum? No. It went to England as a draft copy of what the people wanted. They got it back with more rights. And now you think you can turn around and destroy those rights. No, you can't. The supreme, absolute and uncontrollable authority remains who? With the people. It's whereas the people, not whereas the peanuts sitting in our parliament lying. And just so that you know, Anne Toomey, every single referendum has to be done state by state. Every single election has to be state by state. Because we only had 5 of the 6 required states at Federation, we did not have enough people enough states to create the first federal parliament. You want to argue that point? I can show you exactly where it is in the Constitution. I don't need to answer to you. I'll give you a chance. You want to contact me, I can show you where the truth is. But you don't really know, and you don't really want to know. I don't care, excuse me, if you've got an AO. I can put my own connotations to that, and they're not very nice. But, Mostyn, you're not the Governor-General. You can never be. The Prime Minister does not select the Governor-General. The letters patent put in place by Queen Victoria, upheld by George V in February 1920 and Queen Elizabeth in 2008, they're all upheld as applicable. Are they? Yes. And if they are, where then do you derive the authority you're talking about? There is none. We were never made an independent sovereign nation. No one from outside this country can give you permission, not even England, to break the Constitution. It's indissoluble. Understand that. And as for that treaty in Victoria, that female is just a nutcase. She needs locking up. The Premier of Victoria is an absolute moron. Absolute moron. You can't sign anything with anybody. And in relation to land, you can't sign anything in relation to land. Land is sold from the Crown. To who? To the person who buys it. How do I know? We've got this before the court. We've got it before the court, and it's gone to the King by way of a couple of people. On the 9th of July 1900, under the authority of 63 and 64 Victoria, the Commonwealth Constitution Act 1900 UK was proclaimed as the Commonwealth Constitution Act 1900 UK as the enabling act to establish the Commonwealth of Constitution and enabling the 6 colonies to become states of a self-governing colony of England under the provisions of Clause 8. And to me, there's not just Clause 9, there's 1, 2, 3, 4, 5, 6, 7, 8 before it. Now, I know you have difficulty remembering that because some peanut told you that that's the case. Well, it doesn't work. The 9 clauses were added by Queen Victoria to clarify how the Constitution must work and the application of its authority. Each state constitution was put in place by letters patent in their original text as was a letters patent for the office of governor. Fact. I've got them, I can show you. Western Australia failed to comply with Clause 7 of the Enabling Act and the Constitution derived from it, and 106 at the same time. Western Australian colony passed the 1889 Constitutional Alteration Act, ignoring the provisions of Clause 7 of our Constitution. That act was wiped out with as having no authority by the interpreters of the Constitution, being the framers under Section 51, subsection 38, as I explained, of the Enabling Act and its lawful interpretation, which is not what the political parties put together. That's not lawful. This section denotes that if land control was not granted by Section 51, then it did not exist in law. That section applies to all other laws. So Victoria, you have no control over people's lands, and they are rightfully tipping off the idiots trying to put towers on there on the say-so of an unlawful, treasonous politician pretending to be the Premier, which doesn't even exist in the law anyway. The true definition of fee simple, its law, is this country under the 9 clauses to the Commonwealth, and it reads as follows. And this is what we got before the court. Still has to be determined. We didn't mess around. Can I have another torch, please? It's a bit hard to see in this corner. The origin of a granting fee simple title, the Abolition of Tenancy Act 1600. Now I'll read it in a section as soon as I get a torch. This corner's a bit dark. One of those will work. Okay. We haven't got any, not even the long one. The one next to the bed. Sorry, I need it. All land in Australia was sold into private hands through a grant in fee simple title. The new owner of this title is required to hold a deed. No, I'll hold it. It's okay. To hold a deed. The original deeds were signed by the governor of the state after first determining that all purchase monies had been paid. Know ye that for the consideration of the said sum on our behalf well and truly paid into the treasury of our said state before these presents are issued, and of all and singular the premises we have granted, and for all our heirs and successors do hereby grant into the said name, heirs and assigns, subject nevertheless to the several respective reservations herein to contain, that we do reserve unto our heirs and successors all minerals. Yes, that's the only thing the Crown retains, is the control over the minerals. How? For and on behalf of the people who are supreme and sovereign in their own right. The Constitution says so, this Act says so. I don't have to repeat it. So when it comes to local government, there is none. You can't speak it into being, and in fact now you have to prove its authority. Why? Because we filed in the court, and you can't. I don't care what Chief Justice of the Supreme Court of Western Australia or any other peanut says, or the Public Peanut Service, being the DPP, Department of Public Peanuts. You cannot speak an authority into being when it doesn't exist in law. You have no authority over land, now or any other time. The lies that have come out. This is not a democratic government. We're not in a democracy. We are, under the provisions of Clause 8, which is law, on the Constitutional Act, which cannot be removed according to the Parliament of England, and you were told that in the Labor Party, but you went against it. Are you telling the truth? No, you don't tell the truth anyway. Oh, what are you going to bring in? Oh, look at that. We're going to bring in digital ID. Well, digital ID, what do you call this? Look at the bottom. There's a barcode. Above that, there's a number. When I went to licensing, I was only there a couple of hours ago this morning, and they confirmed what they told me before. It's a digital ID. Who gave you permission to get a digital ID when we said no to an Australia card, which was basically that? We said no to you having that. Why have we still got one? Why have you put it in there? Because you were going to lie to the people and oh, it's already there, so it's there. No, it's not. Your own act says you need our permission, but you've gone ahead and broken your own act. So your act's invalid. But it wasn't a lawful act anyway, because we don't have any lawful parliaments in this country. One by one, each state by 1975 had removed their constitutions, the only authority for those state parliaments to exist. You removed them. So under what authority are you operating now? Nothing. Australia Act doesn't exist. You don't need a referendum according to you and to me? Well, I don't know where you were taught law. But any alteration to the Constitution, right down to one letter, you were told in the federal parliament, or the parliament was told, change one letter, you need a referendum. If it changes the outlook of the Constitution, you remove and replace the Queen of Australia and you think that's funny. You refer to the Statute of Westminster, Adoption Act. Well, the Statute of Westminster is invalid. Where's the evidence of that? Very, very simple. They did go to England. They did go to all the other places and put together the Statute of Westminster. In the middle of the war, in 1942, they created the Statute of Westminster Adoption Act and backdated it to 1931. There's the invalidity. The Constitution prohibits backdating laws. Prohibits it. And you talk about the Royal Styles and Titles Act. Where in our Constitution does it say the Parliament can override the will of the people, don't go to the people and create an act which changes the royal style and title of the Queen or King or whoever. It doesn't. Where does it say we can have a Prime Minister? It does not. What was the first Prime Minister of Australia? The foreman of the Parliament, the Speaker. Did he have all these extra powers? No. How do we know? The interpreters said, neither the federal nor the state parliament are sovereign bodies. They're simply legislatures with limited authority. If they attempt to pass a law in excess of that authority, the law is a nullity and affords no obedience. So now where did you get your authority? You did not have it. You need a referendum? It wouldn't work. Did you need a referendum for the Australia Act? Wouldn't work. Because it was an attempt to change the Constitution. Now you're claiming it did. Then you claim in Sue versus Hill that you had the authority to remove England and say it's a foreign nation. No, you didn't. Where did you get that authority in the Constitution? Didn't have it. Where did the High Court get the authority to rule outside the provisions of the Constitution in any other role other than to deal with appeals against the law of the state that didn't exist under our Constitution, or alternatively to interpret our Constitution? But then when you go to page 791, our interpreters of our Constitution says not only the High Court but every court of competent jurisdiction can declare a law of the Commonwealth of the state to be invalid by transgressing the Constitution. Is that correct? Yes, it is. That's the wording in the Constitution. Now, we don't have any state courts. Not one. New South Wales removed its constitution in August 1902 and replaced it with another one. So New South Wales has been out since then. They didn't even have any authority to remove and create the ACT without reference to the Constitution in section 123. And they didn't use it because you don't know the Constitution. It's one thing to read from a paper or a ticket strip that flows across and you're reading from that. And to me, I watch your eyes. They were fixated on a particular section of your screen. That's okay. You can do it that way if you can't remember. I was born with an extra good memory, and it's enhancing as I get older, not determining and going down, no. And as for all these scare tactics in relation to drivers, the only law that's in place in Western Australia in relation to drivers is in relation to P-plates and how they're going to manage it from now on. There is no other laws. We've always had, by the time you're 80, you've got to do annual checks. I've already had my check, and my next one is 2028. And it's written on my license. I have no problem with that. Last medical I had, I don't have any problems at all. None. No high blood pressure, no diabetes, no nothing. I did not get the jab. I didn't bother. And I'm not listening to any garbage that says it's good for you. It's my body. I decide what's in it. And you cannot be conscripted for medical reasons under 23A of the Constitution. 51, subsection 23A. If you don't like that, boo-hoo. Get over yourselves. I suggest, Anne Toomey, that you stop your constitutional clarion. Go back and review every single decision that you made, everything that you said, and apply it to the red constitution, not the green one. The green one is nonsense, you know it. The political parties all know it. You cannot have an election at federal level. In 1889, Queen Victoria issued a letters patent telling every state how elections will be run. A lawful Governor-General prorogues the Parliament, dissolves it. Well, that's interesting. If it got dissolved, how come Albanese went in and resigned as Prime Minister and then made application to be reinstated and you did it? Under what authority? The fairies? It was on the internet, it was on Channel 2 on the day it was done. And how, excuse me, how did the purported Governor-General, because she's not, how did she create the cabinet? Oh, that Albanese said I picked my cabinet. Oh, you go out and pick your nose too? Is that what you do? Because I'll tell you now, you didn't pick anything lawful. The Governor-General, under the provisions of 62 to 68, must select 10 from the lower house, 8 from the upper. They are the Executive Council. They, with the Governor-General and the Attorney-General, who is a legal practitioner of more than 5 years but not a lawyer, and there is such a thing, always existed in British law, had to put all the laws together on the advice of the Parliament. That Parliament tells us exactly what we want the government to do. We tell the government, our politicians, this is what you want. We want you to put to the Parliament and to the Executive Council. It's all debated, and they put the legislation together as a bill. It goes to the lower house. The lower house sorts out any mistakes, spelling, whatever, and puts it together. And from that, you create a potential law. It must then go to the Senate, who makes sure that it complies with the Constitution. Lee Butter, you can laugh all you like, you're a moron. Laugh at the truth, you're a moron. Now, that law, if it complies with the Constitution, binds the court, binds the Crown to a law made pursuant to our Constitution. That is called due process of law. Part of it. You think I'm wrong? Try it out. How do you think Western Australia got told it could not secede because of the Constitution? Because you can't. The Constitution is a binding document, the supreme law of this country. It is a supreme law. Cannot be overturned, cannot be altered, cannot be touched, because it was made letters patent. A letters patent can only be altered by the reigning monarch. Your version in one of your videos, which I saw, and to me, is absolute nonsense. You better go back and redo that, because it's not true. And if you're teaching our kids that, you've got to be removed from where you are. You want to debate the law with me? Well, that's fine. Any day. Any day. You don't worry me one little bit. Not as anybody like you. Because you set yourself up as an expert. Paul Sims, don't use that language on my Facebook page, please. Now, what I expect is you and Toomey go back and start studying the Constitution properly. The red one and the original Constitution Act, you find out it's explained fully what the intention of the people were. See, Justice Heenan, in front of the Supreme Court, asked me questions on the Constitution, and he tried to say, oh, doesn't the Constitution evolve? I said, if you call lawful alterations under 128, yeah, of course it does. Lawful alterations. It evolves to the truth above what it says. In other words, if there's a fault in it, it can be altered by a referendum. It still must go to the Queen or King for signification, as in 74 of the Constitution says. Any alteration to our ability to go to the Privy Council must go there as well. Don't like that too bad. It's a granted right. It's a granted right. All I'm trying to instill in the people is, look at your Constitution, learn it. If you haven't got it, give us a yell. You can either get it off our dear little friend who's selling them in South Australia, or we can send you a copy, PDF, whatever. So it's out there, so the truth is out there. So when Albanese decides he can change our currency, no, he can't. He needed a referendum, or the people who changed it. You see, I started high school in 1961 actually, and from 1961 to 1966, they forced decimal currency on the people. Never went to a referendum. Do we have to have it? Yes, because the Constitution says pounds, shillings, and pence. Clear. If you change it to dollars and cents, a clear change of the Constitution needs a referendum. needs a referendum. Are you going to try and tell me, no it doesn't? Then that would be a lie as well. Every alteration needs a referendum. We had no referendums, and we can't even call one now because we don't have any lawful states, and we certainly do not have. Did they change Defender of the Faith? No, they can't. They didn't, because they can't. They can't. The royal style and title of the Crown remains in the hands of the Crown. The Crown in British law is God. There's a Crown Corporation, which is the City of London, which all the lawyers swear their oath to, which is the reason why 44I applies to them and is under challenge in the court here. Every court in this country, right up until the High Court, including the High Court, because of the 1979 Act, is under challenge. If you think I'm wrong, prove it's lawful. You can't. You cannot. We've got the legislation that says you can't. The Constitution says you can't. You have no power to alter or interfere with the High Court in any shape or form, whether you like it or not. And no, you don't have the right because it's this, that and the other thing. And no, you got that wrong too. Someone's lying to you again. If it's AI, it's time you've got a action stuck through your computers. If the AI is the only way you get any information, then throw it all in the bin. It's a load of garbage. Tim Dwyer on Facebook will give you a copy of the Constitution, you people that are asking for it. We lost a lot of money when we converted. It took from the time I went to high school until the time I left, and right up until 1966, when I turned 18, to change fully to decimal currency. It's in the book. It's in a book presented to me by a young bloke in Victoria who's studying it all, and he has a copy of that. And it explains it fully, exactly what I remember. I went to Kalamunda High School. Anyone can check that out. My class and the other classes in the high school at the time made the letters for the front of it and the shield on the front, under the instruction of Mr. Munsell, our metalwork teacher. Mr. Miller was our woodwork teacher, and Eve Calder was my form teacher. Check it out. My memory is perfectly good. And you people have no idea. It's Tim Dwyer, not Quire. Sorry. Tim Dwyer, not Jim Dwyer. Tim, T-I-M, for the correction there. And he is on the phone. He's also on Facebook. You can look it up, and he's more than willing to supply you a copy for a minimum amount, which he has to pay, including freight. That's all I can do. Yeah, you can contact me at Tim's Truth, not a problem. Go for it. Now, what I'm going to say is, before you listen to any more nonsense from this government, they don't have the power to turn our currency into digital. They have no power to carry on the digital ID. If they do, when did we make them sovereign and supreme above us? They can't sign any overseas agreements. So all the ones signed by Albanese, Penny Wong and all the other donkeys with the WHO, the WEF and all the rest, all lies and nonsense, put it to the people. Because without it, it's fraud. Can the people react? Yes. Where they react, not my problem. And I agree with the federal police, if they were lawful, that they stop these people threatening people. What's the point? Violence is never going to solve a problem. We've got enough in our heads to destroy them with the truth. We don't need violence. Wake up. Don't threaten people. You can threaten to take them to court. Good. They belong in court. But we don't have any lawful courts until they prove their authority. We don't have any lawful police till they prove their authority. We don't have any lawful lawyers till they prove their authority given 44I of the Constitution. Is it still in place? Wouldn't matter about Sue versus Hill. The 1999 referendum, we voted to keep the Crown and all the laws and everything else attached to it. Bar none. And we are not a self-governing whatever you want to call us. We are not that. We are a self-governing colony of England till we the people say so. And we did say in 1999, 26 years ago. We literally said, pull your heads in, you're wrong, we don't want it. Why have we got your garbage? Why have you got your garbage? Because people need to wake up, and as they wake up, you hate it. Because we get in your face and you hate that too. And as for the federal police, you're not. You're the Commonwealth police or you don't exist in law. Go read your own law. Where does your ability to live, to exist come from? Imperial law. Not acts of the Australian government, because the Australian government doesn't exist. It does not exist in law. It's either the Commonwealth Parliament or it doesn't exist. Look at the page 701 in the Red Constitution. Draws you a perfect map of how our Parliament must exist and sit. It doesn't matter how many professors come out and profess nonsense. It doesn't change anything. It doesn't alter anything. It's time that people woke up, understood. I've never shut my door to anybody. I am no longer available to help people with papers for court. Simply, I don't have the time. I have other things people want me to do, which I have to go back to. And then one includes go back doing more videos. I spent the last 3.5, nearly 4 weeks researching everything that I've said today. And I'll tell you now, it's fact. If you got any law to the contrary, don't try scrubbing me off using AAP and saying it's false and misleading information or whatever other nonsense. Come to me and show me and I'll correct it. But do not come with the Green Constitution or any so-called legislation because it's something's a statute. One of your videos you said Magna Carta is a statute. No, it's not. Magna Carta is a Bill of Rights. It's rights granted through imperial law into this country. It established, in part, the Commonwealth. Our Constitution is based on an application from the people for permission to have a Constitution. It was granted, along with modifications which gave us the authority over every aspect of our lives and every aspect of the governance of this country. No politician representing any political party or anybody else other than us has any authority whatsoever. You want to argue that fact, that's fine. I'm up to it. When do you want to start? When do you want to start? I'm sick of the garbage. I'm sick of the garbage. It's time the people in this country spewed you out for the garbage you are and the lies you tell. And that's 99.99% of every politician sitting in the parliament in this country. You're all liars and frauds and traitors. I don't care what you think. If you belong to a political party, you're sitting in treason. You have to be selected. And I'll go back to this little thing because it needs to be clearly made. When the Governor General, a lawful one, which we don't have, because it has to be a he, not a she. You don't believe me? Read your Constitution. It refers to him or he, not she. That is a word in the Constitution. You want to alter it? Where's your referendum? Can you do it? No, you've got to go back to the British Parliament and send it for the Queen or King's signification. That's all, simple. But you don't want to do it. You don't want to do it. So when he does prorogues the Parliament, he issues writs. To who? The governors of the states. So every single state selects their own candidates, not from political parties. Not from political parties. That's why we're in the mess we're in. Because most political parties are full of lawyers, liars, or they're both the same. No difference. And we select from a group of people put together by the governors of the states. And those representatives, one person once under Section 8 for the Senate, one person once for the House of Representatives under Section 30. One person. Not multiple choices on their criminal documents put out by a criminal, non-existent, unlawful, treasonous federal parliament. Because that's all you are. A bunch of thieving liars and frauds. You don't like what I said? I don't care. I don't care how you feel towards me. It doesn't matter one little bit. I can deal with that. I got broad shoulders, broad enough anyway. I'm not going away. I'm doing this job for my kids, for my grandkids, and their kids, and their grandkids, and all of yours. Because the truth needs to be put out there so we can be governed for, not governed over. And you cannot sign us up to the one world government, which is what your intention is. And you can't do it. Why? Because you, the Labor Party, went to England to try and divide Western Australia off. And England said you can't do it. Doesn't matter what the people wanted. We joined in one indissoluble federation of the Commonwealth of Australia, not one corporation known as the Australian government and all the rest of the bunkum you come out with. Because that's all it is. Bulldust, lies, fraud. So you deal with that. We go back to court on in April next year. 6 months for adjournment, for a hearing. The magistrate was told you're not having a hearing until such time as you prove jurisdiction. He can't do it. We know he can't. You know he can't. And you cannot have the local system of local government that you got. Roads, footpaths, and parks. Nothing more. You have no control over land. If you do, prove it. That's before the court. Every court in the country, every lawyer. It's all under challenge. Every police officer, because you're public officers. You can never be officers of the Crown. You're a creature of statute. Not my ruling. Kirby said it. Now, you've got a bigger problem. Fee Simple wipes out all the other crap. And you've got to show where in the Constitution your authority comes from. Chapter 3, Section 76, page 795, the fourth paragraph says so. Who governs that? We did. So the people said so. You show us where in the Constitution your authority has come from. You and to me, you show it, or shut your mouth and get off our computer and stop putting out these lies. Stop putting out the lies. Read the Constitution and comprehend what I'm saying. Get the red one because it's the truth. It complies totally with the Commonwealth Constitution Act 1900 UK, an enabling act and a binding act put in place with a letters patent. It says on it. So you have a lovely day, and I hope it gives politicians something to think about. You're sitting in treason and fraud, whether you like it or not. And no, Darryl O'Brien, I don't have blinkers on. You have your head where it shouldn't be. Wake up. There is two versions. I just showed you. One's truth, the other one's lies. Have a lovely day.